Hi, I'm Connie Fuchsa with FooteTitle Group, where we know how overwhelming and stressful the home buying process can be, and it is our mission and our passion to make sure that the process is simple for you by keeping you in the loop every step of the way, and that you understand everything that's going on, and we explain everything as you're going through the process. We also ensure that you and your home are fully protected when you walk away from that closing table, so you never have to worry about somebody coming back after the closing and claiming some kind of ownership interest, because you are now protected. Hey, if you're tuning in, please check in and let me know that you're on with us, so I can recognize you and I can see where everybody's tuning in. And also, if you have any questions or anything you don't understand, please let me know. Check in and let me know any questions that you have. So first, I wanted to talk about, hey Kathy, how are you? First, I wanted to talk about powers of attorney. So a lot of times I'll have people say to me, well, you know, the buyer is scheduled a closing for a certain time and I'm the seller and I can't be there. So what do we do about that? So, and likewise is true for the power of attorney. Great, I'm so glad that you're tuning in and hope you had a great weekend. So power of attorneys can be done either for a buyer or a seller. Typically for the seller, we can prepare the power of attorney in our office. The buyer's power of attorney typically needs to be handled through the mortgage company, or at least has to be approved by the mortgage company in order for someone to be able to sign the documents on the buyer's behalf, and that they have all of the requirements that the lender requires. So when we talk about power of attorney, let's start at the beginning. A power of attorney is a document that someone gives the power to be able to sign their name on their behalf to someone else. And so typically if someone's selling a piece of property and they're not able to attend that closing, the person that can't be there may sign a power of attorney authorizing someone else to sign documents on their behalf, and in that respect convey the ownership of that property through that closing. As far as a buyer is concerned, the buyer actually, same scenario, can't attend closing for whatever reason, and they would sign a power of attorney giving power to another person to sign all the documents necessary to purchase the property and to get a loan. Can a realtor be a power of attorney? Great question, Kathy. That is solely up to that realtor and or their broker. A lot of times brokers will advise realtors that they don't want them to be power of attorneys because there can be some liability involved. You know, obviously if you have power of attorney for someone else and you're executing documents on their behalf and they're not happy about some of that, then you know there could be some concerns about that. So what we usually hear is that a lot of the brokers' offices will recommend that their agents do not use a power of, or do not become someone's power of attorney for that reason. But there is no rule that says they can't do it unless it's in the real estate community that that's the case. But no, there's no rule. There's no rule about anybody who can or can't be a power of attorney, as long as the person is above the age of 18 and is mentally sound and stable and doesn't have any mental disability, because those things are issues that would cause those documents to be invalid, whether or not it was power of attorney or if they were actually executing documents on their own behalf. So it has to be someone over 18, and they have to be mentally capable of knowing what they're signing and executing those documents. The other thing about a power of attorney that I want to point out to you, number one, well, a couple of things. Number one, the person who has the right to sign on another person's behalf. So that attorney, in fact, is what we call them. Hey, Joan, how are you? Thanks so much for tuning in. And if anybody else is tuning in and you haven't check in with me just so I can let you know, so I can know who's on, and it helps me be able to answer some questions later as well. So if you would check in as you're tuning in with us. And again, thanks so much for being here. So as to the power of attorney, the person that's given the right to use that power, hey Becky, hope you're having a great evening. Thanks for tuning in. The person who has the right to use that power cannot give that power to someone else. And that's a question we get a lot of times. Say, for example, I am not going to be able to be at a closing and I'm selling my home and I give the power to my mom to sign documents on my behalf. And say, for example, something happens and my mom can't be there either. My mom cannot give that power to someone else. That's not one of the rights that that power of attorney has. Power of attorney is what's called a fiduciary responsibility, which means you've been given a special responsibility that only you can use, and the only person that can give it to someone else is the person that actually gave that right away. Hi, Pam. Thanks so much for tuning in. So glad to have you here. So as respect to that giving that power of attorney interest away, as I said, the person who has been given that power of attorney right cannot give it away to anyone else. So what would have to happen in that scenario is my mom would have to come back to me and say, hey, I can't be there. You need to give the power of attorney right or interest to someone else. And so then we'd have to execute a new power of attorney that gives that right to someone else, that responsibility to take care of those documents, signing those documents on my behalf. So the power of attorney right can't be given away. The other thing is the power of attorney, in order for us to actually use it to execute documents, we must have the original at closing. So before the settlement actually happens, we would need to see a copy of it and make sure if it was executed somewhere else and it wasn't a document that we prepared and executed in front of us, then we would need to see that document in advance to make sure it meets all of the legal requirements to be able to transfer those documents. And the other part of that is, at that point, we can just see a copy. It can be an email, it can be a fax copy, and that would be all that would be necessary in advance, just to make sure we get a chance to review it in advance. But the other thing is, at closing, we must have the original, or before, but at closing, we have to have the original. And the reason for that is because when we go to record the document, so we have a deed that the seller or the seller's power of attorney is signing on the seller's behalf. That deed is recorded in the land records of the county, and that's the document that actually transfers the ownership. So we have to actually record that power of attorney with that deed to show that the person signing it had the right to be able to do that, and we have to have the original to record with that deed. So I know sometimes at closing people will bring their original and then we'll say, well, we've got to take that and we'll get it back to you as soon as it's recorded. And a lot of people don't want to give up that original power of attorney, and I understand why, because that's all of the that's the document that gives them the right to do the things that they may need to do. Particularly when you have a general power of attorney that somebody can use for a lot of different types of things. Sometimes that may be difficult. So we recommend some different things. Maybe that individual takes that power of attorney to the courthouse and records it themselves, and then just gives us a copy of the recorded one so that we can reference that in our deed, and so then the trail of the chain of how that person got the right to sign those documents, then we'd be able to follow that. Or we can send it to the courthouse, and in some jurisdictions we can get documents recorded the same day, and then we could get the power of attorney right back, get it right back to the person who has the power. Some jurisdictions you can't record right away, and there's absolutely no option for that other than to send it to the county and wait for them to record it and get it back to us as quickly as possible, and then we can get it back to the rightful owner as quickly as possible. And so that's something to know, because I know there's an uncomfort level sometimes about giving that original power away, especially, as I said, if it's a general power of attorney. So we would need the original. If a buyer is using a power of attorney and it's prepared somewhere other than a form that the lender provided them, then they're going to need their lender to review that power of attorney and make sure it meets all of the requirements that they have in order for allowing someone else to execute loan documents on the buyer's behalf. So that's really, really important in advance of closing, that the lender has the opportunity to review that power of attorney. Now, of course, if there's no lender involved, then we'd want to review it and make sure it has the pieces that we need to make sure are included. But typically, if there's a purchaser, more than likely they would need to borrow money to buy their house in most cases, and so the lender would need to review that. So hopefully that answered any questions or thoughts you might have had about a power of attorney. The other thing I wanted to talk about is estates. So if the person that's selling the piece of property is no longer with us, they obviously can't sell a piece of property. So how do we find out who actually owns that property, or who can actually transfer the ownership of that property? So in the state where that property is located, an estate needs to be opened. And that's instrumental in the conversation because when someone passes away, let's say, for example, someone passed away that owns a piece of property in Maryland but lived in New York, and in New York an estate was open and their estate was all dealt with, but it was never actually opened in Maryland. Why does it matter that it needs to be opened in Maryland? Well, because someone has to act on the behalf of that estate. That person isn't alive anymore, and so there has to be a person appointed to be able to act on that person's behalf or that estate's behalf. So an estate has to be opened in the Register of Wills office, in the local county office, or in somewhere in the state of Maryland, and that Register of Wills has to go through the procedures that they have to establish and appoint a personal representative or an executor of that estate. And once that person is established and appointed, that person has the authority to act on behalf of that estate, which would include selling the piece of property and transferring the ownership to another person. If the estate is not open, then we have no ability to allow someone to sign documents transferring the ownership of that property because there is no one that's that owns that property at that moment. And that's the legal procedures that have to be done in order to establish an estate and somebody signing on the behalf of that estate. Hopefully that gives you a little bit of information. What we would require on that estate issue, if it had already been opened and a personal representative is established, then when we find that out, that the person is no longer with us, we would require a death certificate and a copy of those letters of administration, which is the paperwork from the Register of Wills that says this is who the personal representative or executor or executrix is. So that's the legal information that we need establishing the ownership to be able to allow someone to sign that deed on that estate's behalf. So hopefully that gave you a little bit of information about estates, a little bit about power of attorneys. Those are, kind of some issues that we deal with when we have owners that aren't there to actually physically sign the documents. Sometimes in a power of attorney situation, we may have an owner that is just out of the area that we can actually send documents to, and maybe they don't want to give power of attorney away. But either way, it's just as easy for us to be able to email documents or Federal Express them to an owner who happens to be in another area, or to a buyer for that matter in another area, and they may be interested in doing that. But either of those options are available. Usually we can come up with a pretty good option for the power of attorney situation. And if you get into this situation and you don't understand what's going on, our team is very well trained to be able to educate you and walk you through the process of making sure that you have all the pieces that you need and what needs to happen if you don't. So hopefully I've answered any questions that you might have. Please feel free to reach out to me, message me, email me, go through our website and ask any of our team members any questions that you might have. Hopefully I've been able to answer some stuff for you. It is my passion to get you as much information about our process as possible. So I like to try to do live videos a couple of times a week to give you some information, but I'm always available for your questions and happy to help you. If I can't answer them, at least get you in the right direction. So thanks so much for tuning in today. My name is Connie Fuchsa. I'm with FooteTitle Group, where we make sure that the home closing process is the simple part for you. Hope you have a great evening, and I look forward to talking to you again soon. Thank you.